X, state your name. Face the TV.
What's this?
Say it again.
Austin Sato.
Mr. Sato, you're before the court today for your first appearance, not with the office of defender since you're not requesting them. You're charged with one count of possession of marijuana less than 20 grams of first degree misdemeanor, punishment to 1 year in the county jail and $1,000 fine. One count of possession of drug paraphernalia, which is a first degree misdemeanor, punishment to 1 year in the county jail and $1,000 fine. One count of resisting officer without violence, which is a first degree misdemeanor, punishment to 1 year in the county jail and $1,000 fine. And approaching a first responder within, after being failing to keep distance from that first responder after they told you to. I'll find probable cause for the arrest. Sir, where do you live?
Thomas Drive.
How long have you lived in Bay County?
Since I was in 4th grade.
Are you working?
No, I'm unemployed.
Okay. Is there a prior record on Mr. Sato?
No, sir.
All right. I'm going to recommend you to the pretrial release program, and I get you out of jail and have to put up a bond. There's some standard conditions you'll have to abide by. The special conditions you'll submit to random UAs as directed by the court or the pretrial release program. Your next court date is June 2nd at 1 o'clock. Good luck.
Step to your right to the T. Give us 1 second, sir.
Ricardo,
State your name, sir.
Corey Gibbs.
if you're before the court today for your first appearance, I'll appoint the Office of Public Defender to represent you. You've been charged with one count of sexual assault by a person 18 years of age of older on a person 18 years of age of older. That's a second-degree felony, punishment to 15 years in the Florida Department of Corrections and a $10,000 fine. You also have one count of grand theft. That's a third-degree felony, punishment to 5 years in the Florida Department of Corrections and a $5,000 fine. I've reviewed the probable cause affidavit. I'll find there's probable cause for your arrest. Mr. Gibbs, where do you live?
1509 Weatherbrook Crossing.
How long have you lived in Bay County?
I've been here for about two weeks to 4 weeks.
All right. And what are you doing here?
I'm up here visiting a friend.
Is there a prior record on Mr. Gibbs?
Florida 25 trespass. The history is mostly out of Georgia. 24 ag assault, possession of meth with intent. 22 marijuana resisting. 21 and DUI and marijuana.
All right. I am going to set a $15,000 bond on the sexual assault, $5,000 on the grand theft. You're to have absolutely no contact with the alleged victim in the case. Your next court date is July 17th at 9 o'clock. Good luck.
Step to your right to the T. When the green light comes on, sign. Red X shirt, state your name.
Okay. One.
Sir, can you state your name?
Okay, 1, 2.
Sir, where do you live?
I live in the United States of America. Do you understand? Can I take a step forward or a step back?
You just stay right where you're at, sir.
Yes, sir. The United States of America.
Do you know what county you live in?
Yes, sir.
What county?
One of the 50. One of the 50 counties. Understood?
Is there a prior record on Mr. Epperson?
Has a battery in 23.
I have a battery. Understood? Just one.
Okay.
Mr. Epperson, you're before the court today on a burglary of a structure. That's a third-degree felony, punishment to 5 years in the Florida Department of Corrections.
I don't know what that means, sir.
Yes, sir.
50-50. That's what I understand. 50-50, white and black, E45. Understood?
Yes, sir. I'm gonna appoint the Office of Public Defender to represent you, Mr. Griffith. I guess you need to
I will
get in
not
touch.
prove an advantage over you on the chessboard. I hope you know that.
Yes. I'm gonna set a $5,000 bond.
Yes, sir.
Next court date, July 7th at 9 o'clock.
Yes, sir.
That was mother called the clerk's office.
A1, A1, AI. Understood?
All right, you can step out for me.
Police need from custody.
Next. Rimmer, come on. Red X, state your name, sir.
Mr. Rimmer, he's before the court today already, this week already, hadn't he?
Yes, sir. It was like yesterday.
All right, I'm gonna set a $5,000 bond on each of these. You got two counts of burglary of the conveyance. Those are third-degree felonies, 5 years in Florida Department of Correction, a $5,000 fine. I'm gonna set a $5,000 bond on each of those. You also have a theft. That's a first-degree misdemeanor. I'm gonna set a $1,000 bond on that. Your next court date is July 21st at 9 o'clock. Good luck.
Step to your right to the T. When the green light comes on, you'll sign for your copy. It's fine. For this one, yes. Step to your right. Step to your right. She's gonna give you a copy. Step in on the red X. State your name.
Ms. Beach, you're before the court today for your first appearance. Mr. Sell is present for you today. You've been charged with one count of principal to attempted homicide, I believe. Is that a first-degree felony?
Yes.
Punishable 30 years? Or life? Punishable to 30 years in the Florida Department of Corrections. Judge Campbell reviewed the probable cause affidavit, found there's probable cause for your arrest. Ma'am, where do you live?
Here in Panama City,
How long have you lived in Bay County?
since October of last year.
Okay, where did you live at prior to that?
Marion.
Okay, and are you working?
Yes, sir. I work at Gulf Coast Hospital and Dr. Memorial Hospital in Bonifay.
What do you do for a living?
I'm a phlebotomist and medical assistant.
I'm sorry, what?
Phlebotomist and medical assistant.
All right, and is there a prior record on this thing?
No, sir.
Mr. Sell, do you want to be heard? Based on the nature of the charge, I'm gonna set a bond. I'll set a bond of $15,000. She'll be able to contact family and friends in order to make the bond. She's to have no contact with any of the co-defendants. Her next court date is July 17th at 9 o'clock. Good luck. July 17th at 9 o'clock.
Step to your T. Step to the T on your right. When the green light comes on,
Yes, sir.
next. Red X. State your name.
Ms. Bang, you're before the court today for your first appearance. You've been charged with one count of petty theft. That's a first-degree misdemeanor, punishment 1 year in the county jail and a $1,000 fine. I reviewed the probable cause affidavit. I find there's probable cause for your arrest. Ma'am, where do you live?
Atlanta, Georgia.
What are you doing in Bay County?
I'm just on vacation.
All right, and are you working in Atlanta?
Yes.
Where do you work?
I do summer camps and I do substitute teaching.
Is there a prior record on Ms. Bain?
No, sir.
Ms. Bain, I'm gonna recommend you to the pretrial release program. That'll get you out of jail without having to put up a bond. Your next court date's June 2nd at 1 o'clock. Good luck.
Step to your right to the T. You can step out. When the green light comes on, sign. Next. Red X, ma'am, state your name.
Demetra Frederick.
Ms. Frederick, you're before the court today for your first appearance. I'll appoint the Office of Public Defender to represent you. You're in charge with giving a false report accusing law enforcement or a government agent of sexual battery. That's a third-degree felony, punishment to 5 years in the Florida Department of Corrections and a $5,000 fine. I've reviewed the probable cause affidavit. I find there's probable cause for your arrest. Is Ms. Frederick on being held on other charges?
You pre-trial released her on a domestic battery yesterday.
What I'm gonna do on that case is is there a case number on that?
For me, I don't have it. Yesterday's case number.
Go ahead.
She's pulling it up.
Was that a battery by strangulation?
Yes,
All
sir.
What I'm gonna do is I'm going to revoke her release on that. She'll be held without bond. I'm gonna set a $5,000 bond on this charge. Her next court date is July 17th at 9 o'clock.
Sir, Ms. Shifton is medically unable to come.
Okay. What I'm gonna do is I am going to first appear on this case. We'll find it. I'm gonna appoint the Office of Public Defender. I'm gonna set a $100,000 bond. She's been charged with one count of trafficking. I'll find there's probable cause. And she's on what is she have a jail for possession?
Yes, and it was a VOP that she had already. I think she's already held.
Okay, all right, I won't worry about that one then. All right, she'll submit the random UAs. Her next court date's July 7th at 9:00. And I'll grant the Nebia hold.
Was that a Nebby on her? 15.
Yes, ma'am.
Thank you, sir. Yes, step in on the red X. State your name.
Jessica Barber.
Ms. Barber, you're before the court today for your first appearance. You're going to be charged with one count of tampering. That's a third-degree felony, punishment with 33 years, 5 years. It's a third-degree felony, punishment with 5 years in the Florida Department of Corrections and a $5,000 fine. Possession of drug paraphernalia, first-degree misdemeanor, punishment with 1 year in the county jail and a $1,000 fine, and possession of marijuana less than 20, which is a first-degree misdemeanor. I've reviewed the probable cause affidavit. I will find probable cause, but what I'm going to do is I'm going to release you on your own recognizances on this case. Your next court date is June 26th at 9:00. You'll submit the random UAs as directed by the court. Good luck.
Step to your right to the T.
That's the best.
When the light comes on, sign. Ms. Watkins just decided she's just not coming. She declined.
Okay. What is she on? What is she being held on?
I think she had trafficking a couple of days ago. What's her charges? We got to pull that up too. Watkins, Linda. She was here yesterday also.
Yeah, just give me a case number on that. 25. Okay. Yeah, just give me that case number on that one we did yesterday. On this new case, I'm going to appoint the public defender to represent her. I'm going to find probable cause. I'm going to set a $5,000 bond. She'll submit the random UAs. On case number 25, CF 1526, I am going to revoke her release, hold her without bond based on this new charge. Her next court date is July 21st at 9:00.
Yes, sir. Next. Red X, ma'am. State your name.
Ms. Myers, you're before the court today for your first appearance. I'll appoint the office of public defender to represent you. You've been charged with one count of possession of methamphetamine. That's a third-degree felony, 5 years, Florida Department of Corrections, and a $5,000 fine. Possession of cocaine, which is a third-degree felony, 5 years, Florida Department of Corrections, and a $5,000 fine. And possession of drug paraphernalia, which is a first-degree misdemeanor, punishment with 1 year in the county jail and a $1,000 fine. I reviewed the probable cause affidavit. I'm gonna find there's probable cause for your arrest. Ma'am, where do you live, Ms. Myers?
I'm sorry.
Where do you live?
Where do you live?
I actually just left my husband of 22 years, so I don't really have an address, but we're reconciling, so.
How long have you lived have you lived in Bay County?
Yes.
Is there a prior record, Ms. Myers?
It's a DWLSI.
Higher what? Higher what? I'm sorry.
He's talking to me.
Pre-trial release program that'll get you out of jail without having to put up a bond. There's some standard conditions you'll have to abide by. The special conditions, you'll submit the random UAs as directed by the court or by the pre-trial release program. Your next court date is July 7th at 9:00. Good luck.
Step to your right to the T. When the green light comes on, sign. State your name, ma'am.
Lisa. Catalina Fredo.
All right, ma'am, you're before the court today for your first appearance. I'm going to appoint the office of public defender to represent you. You've been charged with one count of possession of cocaine. That's a third-degree felony, punishment with 5 years in the Florida Department of Corrections, and a $5,000 fine for one count of possession of drug paraphernalia, which is a first-degree misdemeanor, punishment with 1 year in the county jail and a $1,000 fine. I reviewed the probable cause affidavit. I find there's probable cause for your arrest. Ms. Corretto, where do you live?
1219 Navy Boulevard, I'm pretty sure.
Okay, and are you working?
Yes, sir.
Where do you work?
Ross as a finance supervisor.
Bay County.
How long have you lived here in Bay County?
About 40 years now, 45 years now.
Is there a prior record, Corretto? All right, I'm gonna recommend you to the pre-trial release program that'll get you out of jail without having to put up a bond. There's standard conditions you'll have to abide by. The special condition, you'll submit the random UAs as directed by the court or by the pre-trial release program. Your next court date is June 26th at 9:00. Good luck.
Step to your right to the T. When the green light comes on, sign. Red X, ma'am. State your name.
Ms. Taylor, you're before the court today for your first appearance. I'll appoint the Office of Public Defender to represent you. You've been charged with one count of aggravated battery with a deadly weapon. That's a second-degree felony, punishment of 15 years in the Florida Department of Corrections and a $10,000 fine. I reviewed the probable cause affidavit. I find there's probable cause for your arrest. Ma'am, where do you live?
On my boat in Masalina,
How long have you lived in Bay County?
4 years.
Are you working?
No, I'm disabled. I have breast cancer.
Is there a prior record on Ms. Taylor?
And she just got put on probation for a felony drop for a criminal mischief. 23, there's an ag back using a deadly weapon. 21 is child abuse without harm.
All right, so she's on county probation now?
Yes, sir.
I just
What
paid it off.
the- We have a case number on that.
25-203 MM.
I'm gonna issue a warrant on that. Well, aggravated battery. I am going to hold her without bond. I'm gonna set a $15,000 bond on the aggravated battery. She's to have no contact with the alleged victim in the case. Her next court date on the felony will be July 7th at 9 o'clock. Good luck.
Step to your right to the T. When the green light comes on, sign next. Red X, ma'am. State your name.
Jacqueline Wayne.
Ms. Wing, you're before the court today for your first appearance. You've been arrested on an interstate out-of-county warrant, Hillsborough County, alleging you violated the terms and conditions of your probation.
Yes, sir.
I see Judge Nazaridian ordered you be held without bond. I'm gonna leave that as it is. I'm gonna have a return date of June 17th. Good luck.
Can I ask a question? I went to court yesterday and was placed on probation. Is there any way that somebody can notify them and let them know that I'm gonna be
72
held?
hours of release. You're not being released.
I-
72 hours of release is when you have,
To report to probation here, but I'm not being released here, so.
exactly, 72 hours of release.
Oh,
Yeah.
oh, release. So when I get released.
You got
here-
3 days to get
Okay,
back.
okay.
All right.
I just
Lady,
wanted to make
step
sure.
to your right for me.
Thank you.
Next. State your name, sir.
Jones, Darnell Jones.
Mr. Jones, you're before the court today for your first appearance. I'll appoint the Office of Public Defender to represent you. You've been charged with one count of camping on the beach. That's a violation of a ordinance, disorderly conduct, which is, those are both second degree misdemeanors, pumps up to 60 days in the county jail and a $500 fine, and one count of resisting officer without violence. That's a first degree misdemeanor, punishment 1 year in the county jail and a $1,000 fine. All right. I'll find there's probable cause for your arrest. Mr. Jones, where do you live?
On the beach.
Okay, and are you working?
No, not at the moment.
What's Mr. Jones's prior record, if he's got one?
Locally, 24 petty theft times 2, DUI, no valid, principal to ag bats, 3 FTAs, 23 battery trespass. Locally, it goes back to 19 with a few more FTAs, and his note is he was just released on the 22nd after a sentence.
All right, what I'm going to do is I am going to set a $500 bond on the camping on the beach, $500 bond on the disorderly conduct, $1,000 on the resisting officer without violence. His next court date will be June 2nd at 1 o'clock. He'll shall not possess or consume any alcoholic beverages if he's released.
Jones, step out to the left. The computer's froze. Step out to the left. Next. Next, sir. State your name.
Captain Clark.
Mr. Clark, you're before the court today for your first appearance. You've been charged with one count of petty theft. That's a first degree misdemeanor, punishment 1 year in the county jail and a $1,000 fine. I'm going to appoint the Office of Public Defender to represent you. I've reviewed the probable cause affidavit. I find there's probable cause for your arrest. Sir, where do you live?
Atlanta, Georgia.
And what are you doing in Bay County?
Vacation.
Okay. And are you working in Atlanta?
No, sir.
Okay. Is there a prior record on Mr. Clark?
Just a less than 20 and 20, and that's it.
All right, ma'am, your mother's on Zoom. Ma'am, if you'll state your name.
Billy Harris.
Okay. Did you hear that, Mr. Clark?
Yes, sir.
All right, I'm gonna recommend you to the pretrial release program. That'll get you out of jail. We'll have to put up a bond. Your next court date will be June 2nd at 1 o'clock. Good luck.
Step out to the left behind him. Next. Riddick, sir. State your name.
William Poe.
All right, Mr. Poe, you're before the court date for your first appearance. Based on your financial affidavit, I cannot appoint the public defender's office. You've been charged with count of driving under the influence. That's a traffic misdemeanor. If it's your first offense, it's punishable with 6 months in the county jail and a $500 fine. I've reviewed the probable cause affidavit. I find there's probable cause for your arrest. Mr. Poe, where do you live?
Panama, or Lynn Haven, sorry.
And what I reviewed was a Florida DUI uniform traffic citation. How long have you lived in Bay County?
Since I was 8 years old. So
Are you working?
14 years, I believe.
Are you working?
Yes, sir. I'm a fireman at the beach fire department.
Is there a prior record on Mr. Poe?
Just a battery last year.
I'm going to recommend you to the pretrial release program. You'll submit to random UAs and breathalyzers as directed by the court with the pretrial release program. You shall not possess or consume any alcoholic beverages. Your next court date is June 27th at 8:30. Good luck.
Step out to your left behind the group. Next. Riddick, sir. State your name.
Mr. Darden, you're before the court date for your first appearance. I'll appoint the Office of Public Defender to represent you. You've been charged with 1 count of trespassing on property. That's a first degree misdemeanor, punishable with 1 year in the county jail and a $1,000 fine. I reviewed the probable cause affidavit. I'm gonna find there's probable cause for your arrest. Sir, where do you live?
Atlanta, Georgia.
And what are you doing in Bay County?
Vacation.
All right. And are you working in Atlanta?
Yes, sir.
Where do you work?
Salesman.
Sir,
Salesman. I'm a salesman.
is there a prior record on Mr. Darden?
Side of Georgia, 23 shoplifting, 22 battery, armed robbery, ag assault ×2, kidnap, possession of a gun and a felony, shoplifting, 21 battery, 20 robbery time. It goes back to 15 in Georgia.
All right, sir. Based on your lack of contacts with the community and your prior record, I'm gonna set a $1,000 bond. Your next court date's June 2nd at 1 o'clock. Good luck.
Do you have there like a cash bond option?
It's a cash surety. Right, step out to the left behind that grouping. Next. Riddick, state your name, sir.
Mr. Huff hasn't been here this week, has he?
It was last week I had Huff. Wasn't it last week or was it this week? It was 2 days ago. Yeah, it was this week.
Okay, these are just added charges.
Yes, sir.
All right, you've got 1 count of burglary of a conveyance armed. That's a 2nd degree felony, punishable to 15 years in the Florida Department of Corrections and a $10,000 fine. And grand theft of a firearm, which is a 3rd degree felony, punishable to 5 years in the Florida Department of Corrections and a $5,000 fine. I'm going to appoint the Office of Public Defender to represent you. I'm going to set a $15,000 bond on the burglary, a $10,000 bond on the grand theft. I know, $5,000 on the grand theft for a total of $20,000. Your next court date is June 26th at 9 o'clock. Good luck.
Step out to your left.
I'm still ahead without.
You just put bonds on the new ones. Do you want to just send copies and we'll just sign them here? If that'll be easier?
Hold on, it's loading. Coming back up.
Okay. Okay. State your name, sir.
Demetrius Venus.
Mr. Ennis, before the court today for your first appearance, I'm going to appoint the Office of Public Defender to represent you. You've been charged with 1 count of carrying a concealed unlicensed firearm, which is a 3rd degree felony, punishable to 5 years in the Florida Department of Corrections and a $5,000 fine. 1 count of possession of drug paraphernalia, which is a 1st degree misdemeanor, punishable with 1 year in the county jail. 1 count of possession of marijuana, less than 20, which is a 1st degree misdemeanor. Mr. King, I'm having a hard time finding probable cause on the possession of the firearm. Looks like it was in a holster in a glove box.
Yes, sir.
So I am going to find no probable cause. Griffith, you agree with that?
Yes, sir. Securely encased.
State want to, have any in response to that? So he'll be ROR'd on that. I'll find probable cause for the remaining charges. Mr. Ennis, where do you live?
The address?
No, just Bay County. There you go.
How long you lived in Bay County?
Like 6 months.
All right, where did you live at prior to that?
Houston, Texas.
Are you working in Bay County?
Yes, sir.
You do for a living.
Moving company, 2-man shop.
Is there a prior record on Mr. Ennis?
Locally, there's a no valid earlier this year, and juvenile in 17, some criminal mischief. That's it.
All right, I'm gonna recommend you to the pretrial release program on these 2 misdemeanors. I'll give the state 72 hours. The state will have 72 hours to amend. But I don't know how you're gonna do it, but we'll see. Maybe right now, your next court date is July 17th at 9 o'clock. I'm gonna leave that as it is and see what the state wants to do. Good luck to you. Oh, you'll submit the random UAs as directed by the court.
Step out. Next. What was that?
I'll just send a copy.
10-4. Step in on the red X. State your name, sir.
Mr. Thomas, you're before the court today for your first appearance. I'll appoint the office of public defender to represent you. You've been arrested on 1 count of possession of methamphetamine. That's a 3rd-degree felony, punishable to 5 years in the Florida Department of Corrections and a $5,000 fine. 1 count of possession of drug paraphernalia, which is a 1st-degree misdemeanor, punishable to 1 year in the county jail and a $1,000 fine. And you've also been arrested on a warrantless arrest for alleging you violated the terms and conditions of your probation. I'm gonna find there's probable cause for your arrest. I'm gonna hold you without bond on the warrantless violation of probation. I'm gonna set a $5,000 bond on the possession of methamphetamine, $1,000 on the possession of paraphernalia. You'll submit the random UAs as directed by the court. Your next court date will be July 21st at 9 o'clock. Good luck.
All right, you can step out, sir. Next.
Can you tell me the time? He said because I missed all that.
You're gonna get copies of it after. Red X, sir. Face the TV and state your name.
My name is Jalen Everett.
Mr. Everett, you're before the court today for your first appearance. I'm going to appoint the office of public defender. You've been charged with 1 count of tampering with evidence, which is a 3rd-degree felony, punishable to 5 years in the Florida Department of Corrections and a $5,000 fine. Possession of drug paraphernalia, which is a 1st-degree misdemeanor, punishable to 1 year in the county jail and a $1,000 fine. And possession of marijuana less than 20 grams, which is a 1st-degree misdemeanor, punishable to 1 year in the county jail and a $1,000 fine. I reviewed the probable cause affidavit. I will find probable cause for your arrest, but what I'm going to do, based on the nature of the charge, I'm going to ROR you on all 3 counts. And you'll be subject to random UAs as directed by the court. Your next court date will be June 6th at 9 o'clock. Good luck. And Mr. King, that's based on that.
You're gonna get a copy of it. Yeah. Next. Red X, sir. State your name.
Cameron Wilson.
Mr. Wilson, you're before the court today for your first appearance. You've been charged with 1 count of tampering. That's a 3rd-degree felony, punishable to 5 years in the Florida Department of Corrections and a $5,000 fine. And 1 count of possession of paraphernalia, which is a 1st-degree misdemeanor, punishable to 1 year in the county jail and a $1,000 fine. Mr. King, that's based on the same allegations, so I'm gonna find probable cause, but I'm gonna ROR you, sir. You'll be subject to random UAs as directed by the court. Your next court date is July 7th, 9 o'clock. Good luck.
Amen. Thank you, brother.
Step out. Next.
We got too
Red
many
X,
felonies.
sir. State your name.
Douglas Lewis England.
Mr. Ingram, you're before the court today for your first appearance. I'll appoint the office of public defender to represent you. You've been arrested for outstanding warrant. You violated the terms and conditions of your probation. I ordered you be held without bond. I'm gonna leave that as it is. Your next court date is July 21st at 9 o'clock. Good luck.
Next. Red X. State your name.
Sir, you're before the court today for your first appearance. I issued a warrant yesterday alleging you violated the terms and conditions of your probation. I ordered you held without bond. I'm gonna leave that as it is. Your next court date is June 16th at 9 o'clock, and I will appoint the Office of Public Defender. And that's June 16th at 9 o'clock. Good luck.
All right, you can step out. You can step out.
Is that hitting?
Next.
Is that a third degree or a
Red
second
X, sir. State your name.
Leonard Stagner.
Mr. Stagner, you're before the court today for your first appearance. I'll appoint the Office of Public Defender to represent you. You've been charged with one count of DUI with great bodily harm to another. That's a third degree felony, punishable to 5 years in the Florida Department of Correction, and a $5,000 fine. You've been a failure to hit and run with the injury. That's a second degree or a third degree. I'll let you know in just a second. And tampering with evidence, which is a third degree felony, punishable to 5 years in the Florida Department of Corrections, and a $5,000 fine. Mr. Stagner,
Where do you live?
In Tennessee, Portland, Tennessee.
what are you doing in Bay County?
Vacation.
Are you working in Tennessee?
Yes, sir.
Do you work?
Yes, sir.
Where?
Where do I work for McKesson?
Is there a prior record on Mr. Stagner?
No, sir.
That's a second degree felony punishment to 15 years in the Florida Department of Corrections and a $10,000 fine. What I'm going to do is I am going to set a $5,000 bond on the DUI, $10,000 on the hit and run, $5,000 on the tampering. Submit the random uraes and breathalyzers by the court. Your next court date. You're also not possess or consume any alcoholic beverages, and your next court date will be June 26th at 9 o'clock. Good luck.
You can step out. That's a wrap.
All right, I certainly appreciate it, everybody. I've enjoyed doing first appearances this last week of the month, last year and a half. I'm gonna miss y'all.
Yes, sir. You're not
Miss
gonna
you
do it
too,
anymore?
Judge.
Now I'm gonna start juveniles Monday morning, the juvenile delinquency caseload.
Ew. Okay,
So-
have fun with that.
I've enjoyed it. Thank y'all. Floyd,
You too.
I didn't see you, Floyd, but I'm gonna miss you.
I miss you, Judge.
I see you.
Just logging in, folks. Go ahead and call your first case.
Thank you. Good morning, Your Honor. This is Nicholas Otten, and there are two cause numbers, Your Honor. For Mr. Otten, there's 25L000299. That's on for a pretrial, and also there's an arraignment hearing, Your Honor, for 25L000421. As far as the arraignment, we would waive a formal reading of the criminal complaint, Your Honor. I'd like to enter a plea of not guilty, but also we have reached an agreed resolution that encompasses all three counts across the two cases, Your Honor. I did upload a stipulated order of continuance that I reviewed with Mr. Otten, and we're ready to go on that when the court is ready. Thank you.
All right, thank you. Good morning, you're Nicholas Otten,
Your Honor.
and August 26th is your date of birth.
Yes, Your Honor.
And do you still reside or receive mail at the 7996 Bridgeport Way address, sir?
Yes, Your Honor.
Okay, great. And you had an opportunity to review the rights that attach an arraignment with your counsel?
Yes, Your Honor.
Do you have any questions for the court about your constitutional rights?
No.
Okay, great. All right, and I see an SOC is uploaded, so go ahead and make your record on that, Mr. Rudin.
Thank you, Your Honor. So this is a 12-month stipulated order of continuance. I described this as essentially a contract to Mr. Otten. So there are certain terms of this SOC that he is contractually obligated to complete in order to be successful. I believe he understands all of that, Your Honor. So what he's going to need to do over the next 12 months to be successful in this SOC is to appear timely at all scheduled hearings, no criminal law violations, update his address if it changes, no use, possession, or consumption of alcohol, non-prescribed drugs, marijuana, or drug paraphernalia, obtain a chemical dependency evaluation within 90 days, start any recommended treatment within 90 days, and to not change treatment parameters without seeking permission from the court first, Your Honor. I did describe to Mr. Otten the fact that he's waiving his right to a speedy and public trial, Your Honor. And so essentially, if he's not successful, this would proceed to a bench trial, and he's waiving his right to a speedy trial with a new commencement date of May 30th, 2026, Your Honor. And I apologize, I usually make that the exact same as the end date, so I'm gonna add that to May 28th of 2026, Your Honor. But he does understand how that bench trial would work if it gets to that point, Your Honor. I do believe this is the knowing, intelligent, and voluntary entry of SOC. Thank you.
All right, thank you. So, Mr. Otten, I'm just going to ask you a few follow-up questions. Your attorney made a great record of how the two of you reviewed this document. So I just want to make sure you understand that you're entering a contract between you and the city whereby you have certain obligations under that contract. And if you fulfill those obligations at the end of the 12 months, your cases would be dismissed. That's your understanding?
Yes, Your Honor.
And so in exchange for this dismissal under these obligations, you've also given up some rights. Most of the rights that attach at arraignment you've given up other than your right to an attorney. So you understand most specifically the speedy trial right and the jury trial right. If you fail to comply with the contract, the court would just read the police report and based on just the evidence in the police report would decide guilty or not guilty. That's what you're agreeing to by stipulating to the police report. Do you have any questions about that?
Yeah, Your Honor.
And did the parties anticipate a review hearing to monitor the alcohol and drug evaluation and follow up? Or was he just going to wait for a triggering event?
Your Honor, I don't think a review hearing is necessary. Mr. Otten knows that he needs to have everything filed within 90 days. And I'll advise him that if you're not able to do that for any reason, contact the public defender's office, but no review hearing should be needed. Thank you.
All right. So, sir, basically you have these obligations, including appearance at all court dates, no criminal law violations, not possessing or consuming alcohol, non-prescribed drugs, marijuana, or drug paraphernalia, but you're also to obtain an alcohol and drug evaluation and file proof of that. So it's one thing to obtain it. It's another thing to file the proof and the paperwork with the court. Okay. So any questions about your obligations under the contract?
No questions, but how would I go? Would I just I'm getting on methadone, and so how would I go about sending it to the court?
I could talk to him about that. Your Honor.
Okay, your attorney will tell you that, so you ask that directly. And any questions about the rights you're giving up or the benefits of the contract?
Your Honor, I was able to talk to Mr. Otten about that. We are ready to go.
Okay, any questions about the rights you're giving up or the benefits and consequences of this contract?
No, Your Honor.
Anyone threaten you, pressure you, coerce you in any way into entering this contract?
No, Your Honor.
Are you doing so, entering this contract of your own free will?
Yes, Your Honor.
Okay, I'll accept the contract as knowingly, voluntarily, intelligently entered. And I'll find that the defendant has been advised of the obligations under the contract, the benefits and the consequences of the contract. And so I have accepted the contract. You will receive paperwork in regards to your obligations under the contract, as well as the end date of the contract. And you'll get notice of that today. Any last questions of the court, sir?
No, Your Honor.
Anything further from either of the parties?
No, Your Honor. Thank you.
No, Your Honor. Thank you.
I'm sorry, I didn't really ask the city to weigh in at all. We just launched into the contract. I apologize, counsel.
For the record, Seth Taninga for the city of Lakewood. No, Your Honor. No issues whatsoever.
Okay, I apologize. I saw you there and then I just plowed forward. So I do apologize. I promise I will let you speak on the next case.
Appreciate it, Your Honor.
All right, and every case thereafter. All right. If you have any motions to dismiss that we wanted to put on the record, we could do that briefly with the people that aren't present.
No, Your Honor, I don't believe we, well, let me, look real quick.
Or were those just for the court to review and sign either way?
Those are just for the court to review and sign.
Okay, perfect. All right, what's your name, please, sir?
Right.
Ray Tautua? Okay, you pronounce it so I do it properly.
Right, so two.
Tautua. Okay, I was close. All right, this is cause number 22L000717 on for pretrial. I'll turn it over to counsel.
Thank you. Good morning, Your Honor. We have reached a resolution on this matter. Mr. Tautua has decided to accept the city's offer for a 12-month stipulated order of continuance. I did go over this agreement in its entirety with Mr. Tautua. I believe he understands everything contained within this SOC agreement, Your Honor. But to briefly recap, it's a 12-month SOC on one count of theft in the third degree. As far as the affirmative conditions that he needs to complete, he needs to do a consumer awareness course online as approved. Additionally, needs to appear timely for all scheduled hearings, have no new criminal law violations, and update his address if it changes immediately with the court and DOL, Your Honor. I did describe this to him as essentially a contract. He needs to do those things in order to be successful, and if he does, the city will agree to dismiss this case with prejudice on May 28th of 2026. If he's not successful, he understands that the court would hold a bench trial and read the police report. And if it gets to that point, it usually ends up a conviction because he's giving up his rights to confront that evidence when he enters this SOC, Your Honor. He understands that. Thank you.
All right, thank you. Any record from the city?
Mr. Reardon is correct in regards to his recitations, and the city believes this is a just resolution regarding the matters of the case. Thank you, Your Honor.
Thank you. Okay. And good morning, sir. I'm going to just ask you a few questions about this contract. It's your desire to enter this contract with the city, is that correct?
Yep. Yes.
And you understand that you have significant benefits in this contract, which include a dismissal of your theft charge if you complete the contract. Do you understand that?
Yes, ma'am.
But you also understand there are consequences to the contract. Through the contract, you waive most all of the constitutional rights that attached when you were arraigned, other than your right to an attorney, and significantly your right to a speedy trial and also your right to a jury trial. So the stipulation part of this stipulated order of continuance is that you stipulate that the police report will be the only evidence reviewed, and a decision of guilty or not guilty will be solely based upon the police report. So you understand that.
Yes, Your Honor.
And you understand that if you fail to comply with any of the conditions, then that is when the court, on motion of the city, would review the police report and make that decision of guilty or not guilty.
Yes, Your Honor.
Anyone threaten you, pressure you, coerce you in any way into entering this contract? I'm sorry, did you answer out loud? I didn't hear you. Did anyone threaten you, pressure you, or coerce you into entering this contract? And are you doing so of your own free will?
Yep.
Okay. And I'll accept the contract as knowingly, voluntarily, intelligently entered. I'll find there's been, or the defendant has been advised of the obligations under the contract, the consequences of the contract, as well as the benefits of the contract, and I do accept the contract. It looks like it's only set for the end date of 12 months from today, which will be your next hearing. Understand, sir, and I'm sure your attorney has emphasized the importance of not only completing the consumer awareness class, but filing proof with the court. So if you have any questions about how to do that, please ask your attorney. Otherwise, I've signed the contract and you will receive a copy of the contract today. Any questions of the court, sir?
Oh, man.
Okay. Sir, I wish you good luck. If along the way over the next year you have any questions, reach out to the public defender's office, okay?
Your Honor.
All right, take care, sir. And pursuant to the uploaded motions to dismiss, I'm dismissing without prejudice and releasing the defendant pursuant to the motion of the city on last name of Hernandez, last name of Hill, last name of Phillips, last name of Steen, and last name of Thomas.
Thank you, Your Honor.
And good morning, Your Honor. This is Wagata Testofsson, Your
Wagata Tesfatsian And we're on for competency review.
Yes, that is correct, Your Honor. And I'd like to make a record on this case, Your Honor. As you can probably see, I'm not sure how clear it is over Zoom. She's in very rough shape physically, Your Honor. I have to be very honest. I am seeing that with my own eyes, and it's quite severe, her injuries. I am requesting for her to release on personal recognizance, Your Honor. As far as the history of this case, as I understand it, she had a competency review hearing that she missed out of custody, Your Honor. And the competency evaluation has not been performed out of custody. My understanding is those evaluations are taking quite some time to schedule. I am asking for her to be released on personal recognizance and setting this matter over just a couple of weeks to give her another chance to be able to appear to have that evaluation occur out of custody, Your Honor. As far as any other holds, I do not believe that she has any, so I believe that she's held just on Lakewood. It appears to me that the case in Tacoma Municipal, she's been released on that as of Wednesday, the 28th. I do believe her health and physical safety is in potentially, at issue here, or at risk here, Your Honor. So with those things in mind, I'm asking for her to have just one more chance to appear out of custody, have her released on personal recognizance, and set both of these over to the review docket on the afternoon of June 17th at 1 o'clock, Your Honor. Thank you.
All right, I'll hear from the city.
And Your Honor, the city would object to the defendant's release on personal recognizance based on the defendant's current status. We see the defendant has picked up a charge in Tacoma Municipal Court on the 27th, and based on the recency of that charge and the defendant's current status, the city is unsure as to whether or not her injuries could have occurred before the 27th, or as defense seems to be postulating, after the 27th. I believe the best way to ensure the defendant's safety would be to ensure that she is in custody, and that would be the best way to ensure that she is safe and whole during these proceedings. So the city would be opposing release of the defendant and would just be asking for a nominal bail to be imposed.
All right, this is defense motion, so I'll let you have the final word.
Thank you, Your Honor. The final word I'd like to make is just looking at the age of these cases, Your Honor. And so the malicious mischief allegation is from November 23rd of 2020, and the theft is more recent from July 10th of 2024. I don't see, at least looking at her DCH currently, I don't see that anything new has come up aside from the possession of controlled substance at a Tacoma Municipal, which is not a violent offense or anything of that nature, Your Honor. Rule 3.2, I believe, indicates that court needs to do the least restrictive alternative for release, Your Honor, and I believe here that would be personal recognizance. The fact that she has been out in the community, even though she missed court, does not appear that she's been picking up a whole lot of new charges. There's just that one, Your Honor. Again, not a violent offense. Based on the nature of these charges, as well as in the gap of time, I believe all of that supports the request from PR, Your Honor. That is my request, as well as for the reasons previously stated. Thank you, Your Honor.
Well, I have significant concerns about the state of her health, which is obvious even over the camera, so I can only imagine how jarring that is in person. That being said, I'm just gonna be honest with you, counsel. I'm not sure release is what is going to help her the most as far as.
The hospital. This is the best, and I'm gonna come back on personal. I'm gonna come back to court. I promise. I'm gonna come. I just didn't know where my court was.
I understand, ma'am. I'm very concerned, and I can't ignore that the last charge that's pending is a controlled substance violation, and my concern is that that's possibly part of the core problem and part of the reason that you're in such distress. That coupled with.
No, it's not.
Okay, I'm not asking for any response. I understand you're feeling very desperate, and so I'm not trying to cut you off to be disrespectful. I don't want you to make any statements that you might regret later. So I'm sorry, Mr. Reardon, did you have something else you wanted to weigh in about?
Just very briefly, Your Honor, something that I did want to mention, and it reminded me when the court said that, that's part of the reason for the request, Your Honor, is that I believe that she would be able to get more direct care if she is released, and that would be going straight to the hospital, essentially, Your Honor. The level of care that she's getting in custody, I'm not sure is sufficient. So that's part of the reason for the request as well, Your Honor. Thank you.
I understand. Well, the concern of the court is there's a terrible history of appearance. And so I'm not looking for a response for that. That's just fact. And I also do appreciate, though, that there is obviously some sort of major issue with her health. Currently, she's held, I believe, on, sorry, Jabs is just a little slow for me today, so I'm gonna look up the bail amount today. I think we're on 2,500 cash or bail bond. Well, give me a moment, folks. I'm gonna have to look at some calendaring. Give me a moment. All right, here's what I'm going to do. I'm going to release you today, ma'am, and you're going to appear next Thursday at the EHM probation calendar at 8:45 a.m. So if you are truly seeking medical attention, you will seek that medical attention and then you will return to court. I'm going to put that date in the court order. If not, then there will be a higher bail warrant that will issue, a 5,000 cash or bail bond warrant that will issue, because you're to appear so that we can track your matter. So I understand we're talking competency, which complicates everything. But I also understand that we could have competency assessed in custody, and that could also efficiently be determined. So I'm not inclined to set this out and lose track of it over months and months. I am compassionate towards medical issues and urgent care, but I'm also concerned about the history of non-appearance, which is almost all that we have, other than her word yelling out that she will be here. So she will be set to June 5th at 8:45 at the Lakewood Municipal Court, a week from yesterday, so in 6 days. And then I'm going to make a note that there'll be a 5,000 cash or bail bond warrant if she does not appear at that hearing. Any questions about the court's ruling?
Just some slight clarification, Your Honor. So that's a probation appointment that's set for Thursday morning, June 5th at 8:45. Is there a separate competency review hearing that's going to be set, or just that probation appointment?
I'm setting it on that calendar. This will be her separate hearing. It's just that's the only calendar that exists there.
Oh, yeah, it's like the probation EHM calendar, Your Honor. Is that right?
Right, it's just the probation EHM calendar, but this is a special set hearing for her appearance.
Thank you, Your Honor.
Okay. And I'm noting the city's objection to the release.
Thank you, Your Honor.
All right, so I've indicated her release today, her setting to June 5th at 8:45 p.m. And if there's a failure to appear at that hearing, 5,000 cash or bail bond warrant to issue. So ma'am, you can, and that this is a necessary appearance. I will attach attorney's contact information on that order. And I certainly hope that you get the medical attention that you need. But if you don't, you are just going to have a higher bail warrant. It's going to be, and we're going to circle right back to where we are today, is having you in custody waiting for some sort of competency assessment. So I wish you the best. I hope we see you next Thursday. And any questions from either of the parties?
None from the city. Thank you.
Thank you.
You got any matters for you? You just gonna call the,
Is there another matter?
no, just the orders of dismissal. Do we need to go on the record for those ones?
Oh, the dismissals? I'm sorry, when you walked away, I said that I noticed that there were cities' motions to dismiss without prejudice and that the court was gonna review and grant those, and I apologize. I didn't say that. I must have said that just outside your hearing. I apologize, but I have reviewed and dismissed and released on each of those matters, on Hernandez, Hill, Phillips, Steen, and Thomas, all that were calendared for today.
Thank you, Your Honor.
Did you want me to do an independent record for each of them?
No, Your Honor, thank you so much. We'll just state that the defense has no objection on any of those motions. Thank you, Your Honor.
Okay, all right, thank you. Anything further, counsel?
Nothing further from the defense, Your Honor.
All right.
And nothing from the city. Thank you, Your Honor.
Okay, we'll we'll be in recess and then we'll reconvene 11 for Nisqually. Thank you. Court's in recess. All right, are we ready to proceed?
Yes, Your Honor.
Great, go ahead and call your first case.
If Nisqually, if you could identify yourself, please.
Juan Jimenez Morales.
Okay, thank you. And that would be case numbers 24L1612, 24L0760, and 25L4076. And that last one is on for arraignment.
All right, your true and correct name. Well, first of all, good morning, sir. Is your true and correct name Juan Jimenez Morales?
Yes, ma'am. Good morning.
And February 1st of 1995 is your date of birth?
Yes, ma'am.
And is the 6524 address still a good address?
Yes.
All right. And did you have an opportunity to review the rights that attach at arraignment with an attorney?
Yes.
Any questions for the court about your constitutional rights?
No, ma'am.
Okay, I'll turn it over to counsel.
Yes, Your Honor, this is Sophia Arnold. Defense will waive a formal reading of the criminal complaint. Ask the court to enter a plea of not guilty on his behalf and stipulate to probable cause for today's purposes only. We have been previously appointed on his other matters, and so we asked to be appointed on this one as well. He did just start working, but does still qualify for court-appointed counsel.
All right, thank you. Based on the previous appointment, I will do a direct appointment to the public defenders. I will waive a formal reading on the new charges of assault, fourth degree resisting and malicious mischief. I will enter not guilty pleas on those matters and enter a stipulation for purposes of setting conditions. At this time, sir, I'll turn to the prosecutor and get their input in regards to your conditions of release, and then I'll allow your attorney to respond. Go ahead, counsel.
And Your Honor, for the record, Seth Taninga for the City of Lakewood. The city is concerned regarding the fact that Mr. Jimenez Morales has a history of domestic violence charges, not only with his 24 cause numbers, but now here with 25 cause numbers. I would like to note for the record, the 25 cause numbers do have a different victim, but this does cause the city some concerns for obviously community safety. Therefore, the city believes that bail is appropriate in this case. The city is asking for $5,000 as well as a no contact order between the defendant and the victim.
All right, thank you. I'll hear from the defense.
Yes, Your Honor. Defense is going to request that defendant be released on his promise to return. Looking at his criminal history, it's not very extensive, and a lot of these charges are back from 2013, 2017. And also, he's aware that he has one open warrant. He just started a job yesterday. He's self-employed, and holding him in custody will also affect his ability to afford rent and care for his two daughters that he is a sole parent of. We asked the court to give him the chance to appear on his promise to return.
And in regards to the no contact order, no objection?
Yes, Your Honor, he can abide by that and does not need a civil standby as the two do not live together.
Okay, and did the city upload a no contact order? Or
I
is
have not, Your Honor. I was just thinking.
Okay, all right, so I'm gonna address the no contact order last, but I'll turn to, anything else from defense counsel before I make my ruling?
Nothing further, Your Honor.
All right, so I did during the recess, look through, court has concerns about a couple things. There's a outstanding warrant just from about a year ago out of Pierce District 1. We have the guilty verdict and an SOC. And so the court does have concerns about future appearance because those 1, 2, 3, 4, the last 4 cases over the last year have all gone to warrant at least once and one is active. All right. And so in regards to Mr. Jimenez, on the new charges, I am imposing bail and some bail on the new charges. And then I'm also addressing some of the outstanding matters as the court has concerns. There was a guilty verdict and now new charges, which are not fact findings, but that is cause concern for the court. So I'll outline on each of the charges for the new cases on the malicious mischief 2,500, on the resisting 500, on the assault 4th degree 2,500, and then on the older charges, I will issue 1,500 on the assault 4th degree guilty verdict, and I'll release on the SOC. As that I see as a little bit different situation. Once the city makes their motion, or if we have some fact finding in the future, we can address conditions on that, but that'll be, they'll be released on that matter unless council would like nominal bail set on that to give him credit on that. And then I would reconsider my decision for release on that. I just wanted to be clear for my basis. So, or you can reserve ruling on that, or I can reserve ruling on that, or you can reserve an opinion on that. Just want to allow everyone to be able to speak their piece on each of those.
Yes, Your
I
Honor.
would prefer the Your Honor reserve ruling on the stipulated order continuance. The city is not making a motion to revoke at this time.
Okay. All right. So turning to the other conditions of release, and then I'll let both parties reserve on that SOC. And I'll order that you appear at all court dates, have no criminal law violations, update your address if it changes, only use your true and legal name and date of birth, and abide by all no contact orders or protection orders. And to clear any warrants if possible, noting the Pierce District 1. I understand if you're not released, that might not be possible. So, okay, so turning to our next court date, and then I'll go through the no contact order in more detail. Did the parties have, or did defense have request for when this would be set next week specifically, or 2 weeks out? I'll hear from defense.
Next week would be great, either Wednesday or Friday, whichever works best for the court.
I'm actually going to set it to Friday. Next week is kind of a tough week because we have a judicial conference, and that's only 1 week from today. So I don't think that's unreasonable. I will set it to next Friday's calendar. And then I will set a out of custody date. Give me just a moment to put that in case he posts bail. That will be June 24th. June 24th at 2 p.m. All right. So I've set those conditions. The next court date, I've attached your attorney's contact information. I'm now going to turn to the no contact order. And I'll just ask, just because I haven't seen the protection order, is the protection order a different victim than this no contact order? To the party's knowledge, if people are comfortable sharing that with me? Or do we
Is
know?
Your Honor asking, is the 25 cause number a different victim than the 24 cause number?
No, I know you told me that and I appreciated that information. It's just, isn't there an outstanding protection order, or are we just referring to a protection order as a no contact order? I guess it looks like there isn't actually a Superior Court protection order, so I'm going to answer my own question. I apologize.
Oh, my apologies, Your Honor.
No, I just scrolled down and I think I would see a protection order if there was an outstanding one. So I think we just have two different, quite possibly two different no contact orders. Okay, and so then the final question of the city, it appears that this no contact order would be limited to the case ending in 076. So I'm inclined to only have that no contact order on that case unless there's a basis to have it on all the cases.
And yes, Your Honor, I realized that as soon as I started creating the paperwork, and hence I started on the only the 4076.
Okay, perfect.
No contact order.
Okay, I just wanted to clarify. I saw them both there, but I just wanted to make a record of it so that we can get rid of that other no contact order. All right, and so then turning to the terms of the no contact order, sir, now I'm talking to you and your counsel that you are to have no contact whatsoever with Olga Huerta Gutierrez. You are not to come within 1,000 feet of her person, her residence, her school if she attends school, workplace if she has a job, her vehicle. And you're to immediately vacate if you have a joint residence. I understand there isn't a request for a civil standby, so that's unlikely. You're not to own, possess, or control any kind of firearms, and this order is good for 5 years from today's date. Understand, sir, you can be arrested even if the person protected by this order invites you or allows you to violate the order's prohibitions. So you need to protect yourself by not having contact with that person until you go before the court and have the order recalled. Any questions about the terms of this no contact order?
No, ma'am.
Anything further from either counsel on the no contact order specifically?
No, Your Honor.
Nothing from the city. Thank you, Your Honor.
All right, I've signed that order. And then in regards to the pretrial release order, any additions, deletions, or amendments? Anything that wasn't clear there?
Your Honor, as far as the SOC matter, I would like the defendant to get credit for those days that he's serving in custody.
All right, so I will impose a nominal bail, but I'll allow the city to reserve an argument because the city can always argue for release. Rarely do they, but I understand the city hasn't made a motion yet and they're reserving on the revocation of that. But given that he is being held on all the other matters, and that was the court's order, I don't think it's unreasonable to ask that nominal bail be imposed. I'll impose $250 cash or bail bond on the SOC. And again, city can still reserve and decide what they want to do with their matters. So I'm not taking any action as far as the revocation today. Okay, so I've added that. Anything else for the good of the order on Mr. Jimenez's cases?
No, Your Honor. Thank you.
All right.
No,
And
Your Honor.
Mr. Jimenez, do you have any questions of the court as to what happened here today at your arraignment?
No, ma'am.
Okay, I'll order that you be given copies of all your paperwork. I've attached your attorney's contact information. You should have your dates and your conditions of release. If you have any questions, your attorney is an expert in their field and they are your best resource going forward to navigate the system. So make sure and keep in contact with them, whether you're in custody or out of custody, keep in contact with them, okay?
All right, thank you, appreciate it.
All right, thank you. That'll be all, sir, and we'll see you next Friday.
All right, thank you.
Take care.
Thank you, Tony.
Yep, no problem. And you're all good to go. You can go ahead and step
All right,
out.
thank you, I really appreciate it, thank you.
Yep.
All right, it means a lot.
All right, Mr. Menace, you can go ahead and walk out. Thank you.
Were there any counsel that you were gonna need a breakout room with today?
Yes, I just got an offer on Abbott and I believe it should go pretty quickly. So she should be the only person.
Okay. And any refusals as far as anybody's aware?
I was told that Miss Kimberly Denau was released. She posted bail, I believe, so she's no longer on the calendar.
Okay, DENEUI?
Yes.
Okay, perfect. All right, I'll make a note of that. And then who's in this folly? Can you give us your full name, please?
Logan Daniel Rickman. RICKMAN.
Logan Rickman, case number 23S0006.
All right, and if you lean back just a little bit, sir, because it's hard for me to see your face. There you go. I just prefer when I'm speaking with people. I know it's awkward over Zoom, but I like to see you and have you see me because I take these matters very seriously, as I'm sure you do, because you're the one who's in custody. Okay, so we're here for on a review, and I'll hear from the parties.
And I'll first defer to the city.
Okay.
And Your Honor, it's my understanding the defendant has yet to complete an evaluation or a victim impact panel. And based on that, the city would be asking the defendant's time be unsuspended in the amount of 15 days. I don't know the amount of time that he is currently served.
Warrant was served on the 28th, so credit for 2 days served thus far.
And the city has no objection to credit for those 2 days.
All right, I'll hear from defense.
Yes, Your Honor. So we acknowledge that these things have not been done. However, Mr. Rickman has had a lot going on in his life, and we just want to make the court kind of aware of that. He's been constantly in and out of jail and resolving other cases. He is currently homeless. He's struggling with mental health and drug addiction. He also has quite a bit of health concerns. He has a really bad heart and is suffering from an infection right now while in custody. So defense is going to request a shorter sanction of 7 days in hopes to, get him the help that he needs after serving his sanction.
All right. I'm sorry, did you propose an amount? If you did, I heard the 15 days, and what was the defense proposing?
7 days.
7 days, okay, I'm sorry. Either I didn't hear it or I lost focus for a moment, I'm sorry. All right, and
I was in compliance. I apologize. I didn't know I was out of compliance.
okay, understood, sir, thank you. Give me just a moment to review, folks.
Thank you.
All right, and so as I understand it, it's a stipulation to the violation. From defense perspective, this was a guilty plea entered February 3rd of 2023. And there have been, let's see, it looks like a sanction was imposed last time I saw you. Gave you 4 days with credit for 2 days served for failure to comply. And I believe there were, at that time, the 2 new charges existed. Yep, that was just in January of this year I saw you. And then here we are today. At this point, I have no doubt that some help is needed and that it would benefit you, because I think any kind of treatment or counseling can help anyone. However, I think we're at the point where it's was a plea over 2 years ago. And so I'm going to impose a sanction and close the file today. And then if you want to get help, you can do that through a new court case, or hopefully you just do that on your own and you stay out of the court system altogether. Because I don't think it's your intention to remain in the court system. And I will give you credit. It looks like since November of 2024, there haven't been any charges. So I think you are trying to stay out of the court system. And I can appreciate that because you know, or hopefully you're understanding that I know the difference between accruing charge after charge after charge, and also just struggling in life and not being able to fulfill what's required. So I'm seeing the difference between those two things, giving you credit for staying out of the court system, but I am noting that you failed to comply with the treatment and the victim's impact panel, and pursuant to the stipulation, I will impose the sanction and then close the file. Give me just a moment. And what I'm going to do is I'm going to order a 10-day sanction, give you credit for the 2 days, and then upon completion of your jail time, your file will close. I am certain, sir, that it's not fun to sit any longer in jail, but I also think that perhaps getting this treatment either on your own timeline, or at least not having this held over your head, it will be of some benefit for you. And so that will be the order of the court. So anything further from either party?
No, Your Honor.
Any
Nothing
questions?
from the city.
Any questions about my sanction today, sir?
Does that mean I'm gonna serve 8 days? Or 10 days?
So, yep, whatever the jail decides as far as good time. I've also attached your attorney's contact information on your court order. They are experts and they were appointed to your case, so that might be a valuable resource for a telephone call. They've got a lot of resources other than just dealing with your legal case. And so I would strongly encourage you, if you're trying to stay out of the criminal justice system, but you're struggling, which I don't know you, but I'm just suggesting you have an expert that's appointed to you. Perhaps that would be worth a phone call or two to get some information from them. So I'm just encouraging you to take advantage of that. Okay, sir?
Is someone gonna contact my King County probation officer, so cause I have a check-in on the 5th, and I think you're telling me I won't be there.
Okay.
I don't wanna go back to jail in King County as well.
Okay, give me just a second, because I will address that if we can, and then I have the clerk telling me something, so give me just a second. Okay. All right, so circling back, you said that you have a King County court date?
Check in with my probation officer.
Okay. And that's on June 5th, you said?
Yes, ma'am. I thought I was in compliance, I did, I thought I'd been doing everything.
Okay. So, oh, is that through the Seattle Municipal Court?
Yes, ma'am.
Okay, I see. All right, I can't do anything about contacting them. I'm not sure what the comfort level of your attorney is, but I can put you in a brief breakout room if you want to talk to her for a moment. But otherwise, you could also ask her about how you would send a message from here to another court to allow them to know where you are, so that that doesn't create a further problem from you. That's the best I can offer there. And then also, I wanted to let the parties know there was a no contact order, which I'm recalling, that was part and parcel to this case, because I'm closing the case. Okay?
Thank you, Your Honor.
All right, you'll receive copies of all this paperwork. If for some reason you do not, you can always stop by the Lakewood Municipal Court when you're released and get a copy, okay? Would you like to do a breakout room? Did you want a moment to discuss with him, counsel?
Your Honor, I believe that we can contact Seattle Municipal Court and try to let them know.
Okay, so there you go, straight from the horse's mouth that that they're gonna attempt to do that for you. That's what I mean by them being experts. They're a resource, and so they really do want to try to do their best for you to help you get on a successful path, okay? And I've watched them for years, so just saying.
Thank you, Your Honor.
All right, take care, sir. Can you give us your full name, please, in the squally there?
Heidi Marie Abbott.
Heidi Marie Abbott, and I believe your counsel wants to speak with you in a breakout room. So I'm going to take a brief recess for her to do so.
Okay. So
And-
what do I do?
Do you see a join on your screen?
Yeah,
Go ahead and click join.
okay. Okay. Okay,
Do you see join on your screen?
yeah,
Click join.
click join.
Yes. And Mr. Tuniga, I'm going to send you a message.
Okay. Is that good? Are we good?
Nope, you're still in the main room. You'll go into another room where it's just us two.
It won't let me. I don't see nobody else on the screen but you.
Okay, ask the officer to come and help you get into the breakout room. And Miss Abbott, we should be all good to go with what we
Thank
discussed.
you.
Okay.
Thank you. Have a nice day.
Oh, wait, we got to do it in front of the judge, so hang tight.
Okay.
All right. We're back on the record. Lakewood Municipal Court, Inisqually calendar for May 30th, 2025. And we are on the Abbott matter, Heidi Marie Abbott, 24L001297. I'll turn it over to counsel.
Yes, Your Honor, this is Sophia Arnold. In terms of the arraignment, we will waive a formal reading of the criminal complaint. We will stipulate to probable cause. We are asking for appointment without a promissory note based on limited income. And however, she would like to plead guilty to 1 count of theft today. And that guilty plea has been uploaded for your review. It is an imposing close case.
All right, thank you. And your true and correct name is Heidi Marie Abbott?
Yes, ma'am.
Date of birth, April 23rd of 1974, so you're 51 years old, correct?
Yes, ma'am.
And do you still reside or receive mail at the 12802 address?
No, that's my old address. I'm not,
Okay.
I don't currently know my new address, but I can get it to you.
Okay, so when you can update that, that's always.
I will.
Benefits you. Okay, I appreciate that. And you had an opportunity to speak with your attorney about
Yes,
the constitutional rights that attach at arraignment, correct?
Yes, ma'am.
And you are prepared to enter a plea today of guilty to 1 count of theft in the 3rd degree. Is that the correct understanding?
Yes, ma'am.
And upon successful entry of a plea of guilty, the city will be moving to dismiss 1 count of controlled substance violation. Is that true and correct?
Yes, ma'am.
Counsel?
Yes, Your Honor.
Okay, so turning to the theft 3rd degree, the council has waived formal reading, and so I'm going to enter the guilty plea. So we'll go through that process. And I will also note for the record that I'm directly appointing the defendant to the public defender as they have done the guilty plea with the defendant. Okay. So ma'am, you understand by pleading guilty, you're giving up significant constitutional rights that attach at arraignment. And you have any questions for the court about your constitutional rights?
No, ma'am.
You understand there's a maximum penalty of 364 days in jail. And while there is a plea agreement for a lesser sentence, I'm not bound to that. What that means is I don't have to follow it. I can impose anything up to the maximum if I decide that that's appropriate sentence for you. You understand?
Yes.
You understand that there are possible immigration or collateral consequences that could result from pleading guilty. Any questions for the court about those?
No.
And is it your statement under paragraph 11 that on July 30th, 2024 in Lakewood, Washington, I did wrongfully obtain or exert unauthorized control over the property of a number I'm so sorry, I'm stumbling over my words. Says I did wrongfully obtain or exert unauthorized control over the property of another with the intent to deprive that person of such property. And that was at Rite Aid. Is that your statement, ma'am?
Yes, ma'am.
How do you plead to 1 count of theft in the 3rd degree? Guilty or not guilty?
Guilty.
Has anyone threatened you, pressured you, coerced you in any way into pleading guilty?
No.
And are you doing so of your own free will?
Yes, ma'am.
I'll accept the plea as knowingly, voluntarily, intelligently entered. I'll find there's an adequate factual basis to support the plea, and I'll find you've been advised of the nature of the charges and the consequences of the plea, and I will find you guilty. Ma'am, you have a right to make a statement prior to your sentencing. You don't have to make a statement, but you have a right to do so. I'll hear from the attorneys, and then I'll ask you if you have any statement you want the court to consider. Okay, I'll start with the prosecutor.
Your Honor, this is an agreed recommendation based on the amount of time Ms. Abbott has spent in custody. That the city is requesting that she spend 43 days in custody and get the credit for the 43 days that she has served. After she has spent those 43 days, the case should close. I would note that she does have a number of warrants in other jurisdictions. She's already taken steps to have those warrants quashed in Aberdeen, and she is on Thurston County calendar for the day. So she is being quite proactive and responsible in addressing those other matters.
All right, thank you. And I'll hear from defense.
Yes, Your Honor, Mr. Tuniga really hit everything that I was going to discuss. We asked the court to follow this agreed upon recommendation.
All right, and any comments in regards to an indigency finding for suspension of?
I just want to go see my little boy.
Oh, she just wants to see her little boy, but so she is she's been unemployed, but she's going to work for her son. She's unaware of how much that'll be, but it'll certainly be under the amount to qualify for court-appointed counsel. So we asked the court to take that into consideration.
All right. All right. Ma'am, did you have anything else you wanted me to know other than
No,
that you
ma'am.
were looking forward to seeing your son? Okay.
I need out of here so I can go see my little boy. I have a 5-year-old son.
Okay.
Yeah.
All right, I've had an opportunity to review your history, hear the comments of the parties, and I will follow the recommendation and impose 364 days and suspend 321, giving you credit for the 43 days served. I'll suspend the fines and costs based on a finding of indigency, and I will take no jurisdiction. The case will close upon the completion of jail time. I've also dismissed with prejudice the controlled substance violation. I'll ask the parties to review the judgment and sentence. Let me know if there are any additions, deletions, or amendments, and I'll order you be given a copy of the paperwork, ma'am. Any questions about what happened here today at your
No,
arraignment?
ma'am. Thank you.
All right. Anything further from either party?
Nothing from the city. Thank you, Your Honor.
Nothing from defense, Your Honor.
All right, I've signed those orders. I'll ask that you be given, or I'll order that you be given copies of those. If for some reason when you're released, you're not given copies of your paperwork, I would request, I'd come to the Lakewood Municipal Court and request copies of that. And just a second, let me make sure that I added the public defender's contact information on the sentencing. That way you at least have that contact should something go awry. Okay, I'm now adding that. All right, ma'am. Good luck.
Thank you. You guys have a good rest of your day. Good luck to you too.
You too.
I don't know if that's a real word. Bob Karras coined that 40 years ago. Cases that declined.
I don't know either, but it's always used, so I guess it's made its way to my vernacular.
It means it didn't get authorized. Let's turn this on. We're on the live stream. And when I came in this morning early, I thought I saw 7, but one of them, anyway, they've given me 5.
Declination is in fact a real word.
Okay, Bob Karras didn't make it up. Good afternoon. This is Judge Middleton. What's your name?
Jeanette Carter.
All right, Miss Carter. We've met.
Yes.
Get into your file. This is file number 25996F. People versus Jeanette Carter. Ms. Carter was arrested last night and charged by the county prosecutor. All right, this is file number 25996. People versus Danette Michelle Carter. Ms. Carter, you've been charged on a formal complaint with possession of methamphetamine as a second or subsequent offense, which is punishable by up to 20 years imprisonment. Maintaining a drug house, which is a high court misdemeanor, punishable by up to 2 years imprisonment as a fourth habitual offender. So I guess theoretically, this would be punishable by up to life imprisonment. Apparently, they executed a search warrant at a house at 113 Rose Court yesterday, and you and several others got arrested. These are serious charges. And you and I have dealt with some of this before. A couple of years ago, you had a methamphetamine charge and you pled to a use, and we tried a probation, it didn't go very well. And we ended up violating your probation and revoking it. Back in 2017, you were extradited to the state of Indiana, and I don't remember what the charge was. You have multiple cases where you haven't paid your fines and costs. 202531 as a retail fraud, failed to pay fine and costs. 21315 OT, no operator's license, failed to pay fine and costs. 21689, another retail fraud, failed to pay fine and costs. And 211200, another retail fraud, failed to pay fine and costs. I didn't add them all up to see how much was owed in those, but some of them have been around for a while. So for those reasons, you had an Indiana case, which I believe was a felony. You had a previous methamphetamine case, which was a felony reduced to a misdemeanor, and the probation failed and was revoked. You have multiple cases, at least 4, where you failed to pay your fines and costs, 3 of which are theft charges. So I'm going to appoint an attorney. I'm going to set a pre-exam conference. Boy, we're going to be busy on June 10th. June 10th at 8:30. And a preliminary examination, June 17th, 25 at 1. Ms. Carter, do you have any source of income?
I received disability.
I'm aware that if you're in custody for more than 30 days, you could lose your disability benefits. But we can discuss this at pre-exam conference. I'm going to set on the amount of $2,500. Reason stated. No drugs and no alcohol. No weapons, no assaultive behavior. Do you think you'll be able to post?
I can't hear you.
I set the bond at $2,500 cash or surety. I'm reluctant to do a PR bond because of the reasons I stated. Do you think you'll be able to post it?
No, I haven't
All
been
right.
in trouble for a while. I mean, I've been trying to stay out of trouble. I haven't been in trouble for a while. I haven't stolen anything. I haven't, and when they came yesterday, I was just sitting downstairs, folding my clothes.
Yes, we'll have to sort all that out. The police were quite concerned about this case. This house is a concern for the Sturgis Police Department for some time. According to the affidavit for the search warrant, recently somebody overdosed there and they had to revive him with Narcan within like the last 2 weeks. So it's a premise. Don't say anything about it.
Nobody's overdosed.
Don't say that.
Tim Pelfrey did. He's in jail now. Anyway, Miss Carter, maybe you're in the wrong place at the wrong time with the wrong people.
Yes, sir.
But you've got your own struggles or had with methamphetamine.
Yes,
and
sir.
If you do bond out, you have to check in with pretrial services because we're going to make sure we get some monitoring here. This house hasn't been condemned. It may be, I don't know, we'll see. But this is a house of, I hate to call it ill repute, that has a different context, but it's a drug house and they want to do something about it. So your bond is $2,500. I appointed an attorney for you. Each of your co-defendants is going to have a different attorney. And I think you'll have Mr. Bush. I think the schedule works. We'll see how it works out. But Ms. Carter, your next hearing is June 10th at 8:30. That time we'll figure out how much you owe on all these other unpaid larceny charges. We worked at it on that probation and you did okay for a while, then all the wheels fell off and we ended up revoking it. But
I ended up doing 28 days and then I was off probation and everything.
yes. All right, I'll see you on June 10th.
Does this mean?
It did say she was in the basement. I'm not sure who's gonna be responsible for what here. Good afternoon. Are you Heather Strayer?
Yes, sir.
This is Judge Middleton. I'm here with Mr. Stickley, the Chief Public Defender. Ms. Strayer, you got arrested last night in Three Rivers. And the prosecutors charged you with assault with a dangerous weapon and domestic violence.
Okay.
The complaint alleges that you were at the address of Mr. Jackson and there and causing some disturbance, and he asked you to leave, and at some point you threw a rock over the fence and hit him in the head. That's the allegation. Police got there, his head was cut, and he had been injured. So they charged you with felonious assault with a rock and domestic assault as a third habitual offender. You're on probation to Matt Huff on a charge of attempting to resist or obstruct the police officer in file 24740FY. We had a forensic evaluation in that case. We were found to be competent. I talked to Mr. Huff about this when I saw that you'd been arrested. He said that you've been doing a pretty good job on your probation, checking in with him, testing. Although your booking report shows you were 0.07 last night, so you've been drinking. That's a condition of probation, not to drink any alcohol. It's also a condition you not engage in any assaultive or threatening behavior. So Mr. Huff is going to file a probation violation for your earlier attempted resisting obstructing charge. Are you still at Maple Crest?
Yes, sir.
Do you have any source of income?
Yes.
What's that?
I get a disability check.
Okay. Just like an earlier lady, I realized that if you're in custody for more than 30 days, it could affect your ability to get your disability. However, I'm reluctant to do a probation. I'm reluctant to do a PR bond because the allegations you threw a rock and hit somebody in the head. Secondly, it's a domestic assault. Third, you're on probation for resisting obstructing police officers. And these are things you aren't supposed to do while you're on probation, including drink. That was very disappointed to find that there was alcohol in your system because you've been testing twice a month. Maybe you've been dodging the raindrops, but he was disappointed to know that your blood alcohol was 0.07. So I'm going to show a plea of not guilty. I'm gonna set a pre-exam conference for June 10th at 8:30. And a preliminary examination if needed for June 17th at One, we're gonna appoint an attorney. We can review your bond status at the time of the pre-exam conference, but the conduct here troubled me, and the alcohol does, and Mr. Huff's gonna file Monday a probation violation. So it's a condition of your bond that you not consume any alcohol or any controlled substance, and take a test as directed by probation, parole, judge, police officer, prosecutor. No contact with Tony Jackson. No weapons, no assaultive behavior. Cooperate with Pivotal.
Yeah, I actually have an appointment this Friday with Pivotal.
Well, he said you were doing a good job. He was very disappointed. I'm referring to Mr. Matt Huff. But because
Yeah,
you're on
correct.
a probation on an assaultive charge and you did this, drinking in violation of the terms of your probation, I'm gonna set the bond again at $2,500 cash or surety.
That sucks. That's okay.
We are,
Appreciate it, man.
because I want to get a handle on it. We'll review your bond further at the time of the pre-exam conference. Your lawyer, I believe, is going to be Mr. Paul Gibson. We'll see how that shakes out. But I'm not sure what you were so upset about. He didn't want you there. You wanted there. He ended up hitting him in the head with this rock. He was cut. They seized the rock for what it's worth. If you do bond out, you need to contact your attorney. If you do not bond out, your attorney will contact you at the jail. Mr. Strayer, do you have any questions?
Is that 10% or is that the full amount?
$2,500, posting 10% with a bonding company.
Okay.
All right, I'll see you on June 10th.
All right, thank you.
If you do bond out, you need to check in with Matt, your probation agent.
The other one that we don't have, Your Honor, I'm just making sure we got this right, is who's not in the multiple rate is Jonathan Simpson, right?
I have Jonathan Simpson, but yeah, he's not in the raid.
Okay.
He has a co-defendant, but not related to this, Rose Street House. Good afternoon, sir. What's your name?
Chris Sears.
All right, Mr. Sears, good afternoon. I'm Judge Middleton. Also here with me is Mr. Keith Stickley, Chief Public Defender. Mr. Sears, the Sturgis Police executed a search warrant at your house last night. You and several others got arrested. Prosecutor has filed some charges. And in your case, the allegation is that you possess methamphetamine and you were maintaining a drug house. They didn't charge you with second or subsequent offense. My recollection is you got 21 meth charge in circuit court. Were you on probation under Judge Stutzman?
No, I'm not on probation or anything.
But were you at one time?
Yeah, like 5 or 6 years ago.
Yeah, who was your PO?
Dan.
Prison.
Dan Frazine? Let me look at this.
I don't remember his last name.
That was 212538. Oh, it was a misdemeanor. It was a felony reduced to a misdemeanor. Methamphetamine retail fraud. Placed on probation. And you completed the probation.
Yes.
Then there was a retail fraud charge in 2022. You live at 113 Rose Street,
Yes,
or Rose Court. Who's owns the house?
me and my father,
What's your dad's name?
Carrie Sears.
But he doesn't live there?
No. My dad bought that house for me, so I had somewhere to live, but I wasn't on the streets.
Okay. Again, there's a prior methamphetamine charge. You appear to be the prior proprietor of the house. I've said with one of the earlier defenders, this house has been a sore spot in the city of Sturgis. In addition to possession of methamphetamine, which is a felony punishable by up to 10 years in prison, fine of $15,000, you're charged with maintaining a drug house. I'll read that. Did knowingly or intentionally keep or maintain a dwelling that was frequented by persons using controlled substances for the purposes of using controlled substance or used for keeping and selling of controlled substances. That's a high court misdemeanor punishable with 2 years imprisonment, fine of up to $25,000. At point of fact, I probably set Danette Carter's bond too low. You have a prior methamphetamine charge. You are the alleged proprietor of this house. The search warrant alleges that within the month that someone overdosed in this house and he had to be revived with Narcan. So overdose would tend to be opioids rather than methamphetamine. Narcan is for heroin or fentanyl. The search warrant says Tim Pelfrey overdosed there recently, and that's a cause for concern. I'm going to do the same thing I did with everybody else. I'm going to appoint an attorney. You and your co-defendants all have a different attorney. I'm going to appoint an attorney. I think your attorney is going to be Rhonda Ives. We'll see. I'm going to set a pre-exam conference for June 10th at 8:30 and a preliminary examination if needed for June 17th, 2025 at 1. I put the same bond conditions on you I put on everybody else. No drugs and no alcohol. No firearms, no assaultive behavior. And if you do check out, you have to check in with community corrections for pretrial supervision. I'm also going to set this bond at $2,500 cash or surety. This is a public safety issue. People are using drugs at that location to the extent that they're overdosing. That's a cause for concern. You do have a previous drug charge, but you did complete the probation. And then a theft charge, which doesn't really carry any weight here.
Would it be okay if I get back into CMH and my caseworker?
Yes, it would be. I'll put in here, cooperate with Pivotal.
Because I would like to get back in with them again.
I think that's a good goal. You did complete that probation, which was a good sign that most people don't methamphetamine probation, but you got to the finish line. And then it sounds like you got caught up in things again. All right, your next hearing is June 10th, $2,500 cash or surety that can be posted by a bonding company. You're not to leave the state of Michigan, not to get in any other trouble. Do bond out, you can't use any drugs or alcohol, and you have to take a test if you're requested. No firearms, no assaultive behavior, cooperate with Pivotal. And if you do get released, I want you to check in with a community corrections officer for pretrial supervision. All right, Mr. Sears, I'll see you on June 10th. I'm gonna be busy that day.
Am I free to go?
Yes, you are.
Gonna take up my whole roster here.
Yes. Well, they're Sturgis cases, so you lose Tim George. And you got 3 co-defendants.
See right there.
All right, looks like we woke everybody up, including Mr. Gary Gilmore. Good afternoon, Mr. Gilmore. This is Judge Middleton. I'm here with Mr. Stickley, the Chief Public Defender. You got arrested last night on a search warrant being executed at 113 Rose Street, where you live. Tell you what the charge is. They charged you with possession of methamphetamine and maintaining a drug house. Possession of methamphetamine is a felony punished by up to 10 years imprisonment and a fine of up to $15,000. Count 2, maintaining a drug house, is a high court misdemeanor punishable by up to 2 years imprisonment and a fine of up to $25,000. You were one of the residents of when they're trying to figure out exactly who did what. I'm going to show you plead not guilty.
Yes, sir.
And I'm going to set pre-exam conference for June 10th at 8:30. A preliminary examination if needed for June 17th, 5 at 1. I'm going to appoint an attorney, which I believe will be Paul Gibson, but that's yet to be determined. Now, the question is, what do we do with your bond? You don't have much of a criminal history. You have some old stuff. You had that gun case in 2023 where you had a felony carrying a concealed weapon reduced to a misdemeanor. Then you paid us back by failing to pay the fines and costs on the charge. The gun was forfeited. Let me ask you a couple questions. Are you employed?
At the moment, I'm not. I'm actually in the process of getting ready to move out of that house. That day, actually, I was supposed to go with my girlfriend to drop some clothes off and stuff, but me and her got into a little disagreement, so I ended up staying. But I'm in the process of moving right now.
Probably a good idea.
Great idea.
So you're not employed. Do you have any source of income?
I do. I actually fix phones and do side work for people.
Okay. I've known you since you were a kid. When I saw this, the first thing I thought is you need methamphetamine, like a hole in the head, as the cliche goes. Had that gun case, which was troubling, and it was reduced to a misdemeanor, and then you didn't pay the fines and costs, which is why I'm not going to give you a PR bond. I'm going to order that you not consume any alcohol or use any controlled substances, including methamphetamine and marijuana, and take a test as requested. No weapons, no assaultive behavior. I'm not going to order pretrial supervision, but I am going to order a bond, $1,000 cash or sure. The reason I'm not doing a PR bond is you had that felony charge reduced to a misdemeanor, got a break, and then failed to pay the fines and costs.
I actually remember what the fines and costs were. I can't even remember what it was.
One of the issues with this, Mr. Gilmore, is trying to figure out who's more responsible and who's not. There are 3 co-defendants and one lady they decided not to charge, and your defenses will be inconsistent. One may say, well, so-and-so was running the place, or so-and-so was selling drugs out of the place, or maybe you'll all say, we weren't doing anything except living there. I guess we'll see, but you have different interests. And so we've appointed 3 different attorneys.
I'm unaware of.
When I see you, I'll tell you. I'm sorry, go ahead.
I was actually unaware of what was going on at the moment.
We'll get into that. Don't make it any more statements.
And that may well be part of your defense.
Like with the side of not having nowhere to stay, I usually distance myself from everybody.
Well, these might be good people to stay away from.
So is that bond like, is that like 10%?
You can post 10% with a bonding company. The file, there's some other older stuff on here, but the one that was the most concern to me was a felony case, 23-1602 FY, carrying concealed weapon, and it was reduced to a misdemeanor. You got 3 days jail credit, 3 days, $350 fine. And as far as I can tell, you never paid 1 cent. So I should set the bond at $350 cash assured or cash, but I can't do that. But we sent you some notices regarding the payment of the fine, which came back. So
Address that I have in.
I'm sorry, I couldn't hear you.
Probably just the address that I had then. I probably moved from there, didn't live there no more. Whichever address. At that time, I was going from the hearth to another residence.
Well, let's see what we showed for residents back then. Rose Street, 113 Rose Court.
That could have been an address. I just got that address on my
Well,
license.
maybe they updated. I don't know what it was then, but anyway, you never paid your fine, which is why you're not getting a PR bond. So I set it relatively low, $1,000 cash or surety. Your next court date is June 10th at 8:30. Repeat your bond conditions: no drugs, no alcohol, including marijuana, no weapons, no assaultive behavior. I did not order pretrial supervision in your case. I did in the others. But if you do bond out, you need to contact your attorney regarding your hearing on June 10th. If you don't bond out, your attorney will come to the jail and see you. I am concerned, as I also should indicate, where there's no PR bond. Somebody allegedly OD'd in there earlier this month, had to be provided with Narcan. And this can be a public health and safety issue. So, Mr. Gilmore, I'll see you on June 10th. If you do bond out, I want you to call your lawyer.
So,
all right, do you have any questions?
No.
All right. I'll see you on June 10th.
So yesterday, like how was you?
Good afternoon, sir. Are you Jonathan Ryan Simpson?
Yes, sir.
I'm Judge Middleton. I'm here with Mr. Stickley, the Chief Public Defender, and you got arrested last night, and I'm going to arraign you and tell you what the charge is.
Okay.
The complaint alleges that in January 10th of 2025, you and a co-defendant, Christopher Harvey, went into the Walmart store in Three Rivers to steal property worth worse than 200 but less than 1,000. That is a misdemeanor punishable up to a year in jail and a fine of up to $1,000. They charge you with a high court misdemeanor of conspiracy to commit retail fraud with Christopher Harvey. Let me look at this, because that should be a preliminary examination. There's no 2-year misdemeanor. Any 2-year misdemeanor is a high court misdemeanor. So let me see what they did with Mr. Harvey. Anyway, let me tell you a little bit about it. Apparently, they've been watching out for Mr. Harvey at the Walmart stores, and he'd been suspected of doing this type of thing before. In fact, he was apparently wearing the same clothes he had on before. Christopher Harvey was identified due to multiple prior instances with Walmart. He stole looks like a Bluetooth speaker, $457. And alleged you were with him. And when he attempted to steal it on this date, they broke the monitoring device off of it with a magnet, and they allege that you picked it up and back on the shelf. Now, what it appears to me that you're charged with is a felony. It says misdemeanor, but there is anything that's punishable more than a year in jail is a felony. Let me see what Mr. Harvey got charged with. He got a $5,000 cash or surety bond.
Sir, I didn't even really know what he was doing at the point, but
Hang on, let's not go there yet.
Don't say anything more about it, Mr. Simpson. Now,
Yes, sir.
you were allegedly from Augusta or somewhere. Do you live in Three Rivers now?
Yes, sir. I moved in with my mom to get away from the bull crap. I just recently had a son, not even 2 months old yet, you know. I've been trying to do my best.
This happened last
year. Yeah, it happened last year.
January of 25.
I wasn't even around him. I haven't been around Christopher Harvey in almost over a year.
Hang on.
January 10th of 2025. Apparently there's a video. January 10th of 2024. You're right.
Yeah.
The affidavit says 2024. The complaint says 2025. To further complicate things, this is a felony, and they did treat Mr. Harvey's case like a felony.
Insurance do you got?
And they charged it on a misdemeanor warrant complaint. Give me one moment. Everybody just stay where we are. All right, well, let me sort this out. There's multiple problems here. The date on the complaint says this occurred January 10th of 2025. It was authorized on January 27th of 2025. But the affidavit says that it occurred January 10th of 2024. So I'm not sure what is correct. Prosecutor also charged on a misdemeanor complaint rather than a felony complaint, but it is a felony. How did you come to get arrested last night?
I was stopped by Kalamazoo, and they said I had a warrant. They called you guys, and you guys said we're coming to pick him up in the morning, and then you guys were there a couple hours later. The officer said, "I don't understand why we're coming to get you. It's only a misdemeanor."
It's a felony, and it's got problems. I can't tell when it happened. The affidavit says one thing, the complaint says something else. So you're not trying to stay away from it. You're right in the thick of it if you're up in Kalamazoo. What time did you get over?
But it happened here. Like, supposedly it happened in 3 Rivers. Like, I was moving. I was in the process of moving. Like, I was with my mother. I was trying to come to 3 Rivers. Like, that's where my son's at right now. Like, I'm not trying to be around them people. I'm not trying to do anything wrong at all.
All right, what's your mother's name?
Lori Simpson.
Are you employed?
I get disability. I'm a full-time father. The baby mom is actually she's getting her mentals taken care of right now. She's mentally, she wasn't okay after having Tanner, you know, she kind of just kept pushing him away, you know, and so she's actually getting some medical help with her
You don't get disability for being a full-time father. What's the nature of your disability?
I got disabilities from my arms. I was in a real bad motorcycle wreck when I was 21, and it messed me up pretty good. I had a really bad back, a really bad neck. My arm is completely paralyzed from the shoulder down.
All right. So you don't have much of a criminal record that I saw, and there's the dispute between whether this happened in 2004 or 2005. I
I'm
can't
not
tell.
gonna cause you, sir. I promise you I will come to court. I have my son to think about now, you know? I want to do the right thing, and I don't want my son to think that it's okay to do bad things. Or
Where does your son live?
He's with my mom right now.
All right, good. Where's the child's mother?
She's in North in Kalamazoo getting help for her mentals. Like I really had to turn my life around. I really had. I mean, I stopped hanging out with groups of people. I moved to
Okay. All right, I'll take it. No, they don't have a criminal history in here. I didn't see anything in our system. Are you on probation or parole?
No, sir. No, sir. Absolutely not. I just want to go home and be with my son.
Yes. Do you know why they pulled you over in Kalamazoo?
My mom was speeding.
Okay. Well, I don't have any criminal history, and I don't know if there is none or we just had an oversight. But I'm gonna set this for a pre-exam conference because there is no 2-year misdemeanor. It's a 2-year high court misdemeanor, which is a felony. So Mr. Harvey's case isn't correct. I set it for June 10th at 8:30. Preliminary examination needed for June 17th, 2025 at 1. This is 2-year felony. Your bond conditions. No contact with Christopher Harvey.
Yes, sir.
I'm gonna give you a curfew, 11 p.m.
Okay. Yes, sir.
6 a.m. No drugs, no assaultive behavior.
Yes, sir.
Weapons. I'm gonna
Yes,
give
sir.
you $2,500 PR bond.
Thank you so much. Thank you so much.
Well, according to this, you were sort of a aider and abettor or bystander to the theft of this thing. The more primary defendant was apparently Mr.
I just
Harvey.
didn't want to be a snitch. I knew what I was doing.
Don't say anything about it. Don't say any more about it.
Okay.
Now, the other problem is the Walmart people recognize you, and Portage Walmart knows you.
Yes, sir.
So I'll give you a PR bond. Have you been charged with anything like this in Kalamazoo County?
No, sir. No, sir.
Yeah, they recognize you as a risk to their store.
Yeah.
Share with other stores.
Well, I don't have a vehicle.
At least you didn't wear
I
the
don't
same
have
time like Mr. Co-defendant did.
I don't have a vehicle, and my mom works. So I'm stuck at the house. I have no way of getting around, and I won't be a mess. I won't cause problems.
All right, all I want you to do is show up. This is a larceny
Oh,
offense.
yes, and I'm
Now,
going to.
what the affidavit says is Simpson was identified by Algarin. I ran his information through Secretary of State, the photo matches. Simpson previously stole the same sort of speaker on 1/8/25. So I believe this happened in 25, not 24. I think there's a typo in here somewhere, but they allege you were in here 2 days before stealing the same thing. So I'm giving you and they got video of all this, apparently. Video footage corroborates the loss prevention staff's version. So it's a larceny, $457. I can't tell that you have any prior convictions. You're not on probation or parole. You do have a physical disability. You're going to be residing in St. Joseph County. Let me repeat your bond conditions. No drugs and no alcohol. These always think this is a methamphetamine case. People are stealing easily sellable stuff, and I think there's a pink elephant in the room, and it's methamphetamine, but you're not charged with that. You're not to have any contact with Christopher Harvey. No weapons, no firearms, no assaultive behavior. You're gonna have a curfew of 11 o'clock, and you're barred from Walmart.
Okay.
Your bond is $2,500 PR. This is a property crime. We're gonna have to straighten out the date. We're gonna have to straighten out the way this was charged. But I believe it's a high court misdemeanor, which needs a preliminary examination. And we'll see what they find out about the alleged theft 2 days before, when there's apparently a video of you stealing the same thing. We'll sort that out. For now, I've appointed an attorney. I'm gonna give you that paperwork. I believe it's gonna be Paul Gibson.
Okay, good.
Now, I want you to listen. When you get out, I want you to call your attorney and make an appointment to dismiss with them. They're
Yes, sir.
apparently this, but the attorney should probably watch prior to the preliminary examination time. The pre-exam conference is June 10th. I may give you, when I see you on June 10th, that's one of your bond conditions. You're not using any drugs on demand of
Yes,
any
sir.
probation officer. I have a suspicious nature, and I am suspicious that this is a methamphetamine-driven stance. Yet to be determined, but you're not charged with that, just theft. All right, you're gonna get out. Will somebody come pick you up?
I probably have to walk to my mom's, but it's only like 9 miles. I mean, I can make it pretty
Well, if you
quickly.
get out and you come to the courthouse, the bailiffs will give you a bus pass to get.
Awesome, thank you. Thank you.
Okay, all right. You're good to go, Mr. Simpson.
Thank you.
And if you need a bus pass to get back, we'll give you that. All right,
Okay,
you're
thank
good
you,
to go,
sir.
sir.
Bye-bye.
It's gonna be a little bit. We have to get everything processed and wait for him to send everything.
Okay.
Yeah, I don't know if he'll be there by 5 o'clock or not, so we'll see. Okay, thank you, Mr. Stickley. I don't know what we got there. I think.
Well, I was
that-
trying to
I
dig
think-
into this statute there. It's a little strange, Your Honor. So under the 157A, it basically implies that as long as it's a year or more, that the punishment shall be a penalty equal to which could be imposed if you've been convicted of committing the crime. So if he really is only charged with the 1 year, it could be a 1 year. That might be correct, with the court having the discretion to give another penalty of up to $10,000.
Well, the complaint says it's a 2-year punishable by up to 2 years.
Yeah, no, I know, and
So
I don't think That's right, but I think there's a couple other issues. We'll jump in.
Well, we'll set it for the pre-exam. So we got Mr. Harvey going in one direction with a misdemeanor pretrial and Mr. Simpson going the other direction with a pre-exam. But obviously we can straighten them out and see, but this gentleman's gonna get out and I don't think he's doing real well. We'll see, but he can't go into Walmart. All right, I think that's all we got. Thank you.
Yep, have a good weekend.
You too. All right. Odd combination of things. That completes our day and our week, I hope. And we'll be back on Monday morning with some criminal sentences and some civil pretrials. Hope everybody is doing well where we are.